my mind, and I said, look, I rang Archana and I said, I have thought about this long and hard, and I've decided that I'm just going to pull out. And Archana said, oh, no, you're not. And she then said other things. And so I said, okay, I'll finish. And if it wasn't for her, I truly would not have finished. Archana is just an amazing, I don't know what to say about Archana. When I started my law course at Macquarie, I really loved the Macquarie Law course. I loved the way that they basically worked on telling you why we have law in the first place. They didn't just teach you law like they did it at Sydney or anywhere else. They actually told you why we have laws and what is law. And one of the very first subjects we did was Chinese natural law. And it was a really wonderful introduction to almost like the Indigenous perspective of the laws of the land and the laws of the nature. And that was really how we got introduced to law, and I loved it. And Archana did family law, and she would bring us in. There was a room full of, oh gosh, I don't know how many people. Archana was looked like 200 people in a room. And Archana would stand up the front and she would ask some of the most difficult questions. And we would just look at each other and think, I don't know how to answer that. Nobody did. And then Archana would give you the answer. You'd sit there and think, that's amazing. You can, and you really, to things that you thought were just inexplicable, she would find answers, and she would be able to kind of take you through this journey of how we got to the answer. And so it was always a delight to be in Archana's class, and it's been a delight to have her as my supervisor. So I think I've said enough, Archana. I'm going to hand it over to you.
Thank you, Catherine, and I hope that people won't take you too seriously. I hope everyone can hear me clearly.
Yeah.
Because I'm not using a microphone, that's why I asked. Thank you for asking me to come and talk to you and to all the people who are there in the room and on screen. I feel quite inadequate in what I'm going to say, because I'm used to being a law teacher, and I'm used to talking to students, and in some ways you already start with an advantage by being a teacher, and everyone has to just be polite to you and go along with what you're saying most of the time. So if I sound too much like a teacher, you can always stop me and say, talk something else. So Catherine asked me to talk about, basically she said, talk about anything that you want to. And I suppose you won't be surprised that I chose to talk about teaching law. But my reason for choosing the topic of teaching law to change the society is basically, it's a wider argument than just teaching law. I'm just using the example of teaching law as a hook on which to hang my argument. And the argument that I will make with regard to law, I think should be extendable to other areas of our experience and to how we organize society in a wider sense. And so if you feel that focusing on law is too narrow a focus, I would like you to please bear with me, because the wider implications of what I'm saying, I think, should be applicable to all other areas of how we organize our society. So since everyone accepts that law ought to be just and fair, and it is amply evident that it is actually falling short of that standard, the question arises more easily in the area of law, that who has the responsibility to do something about this, and how may we discharge this responsibility? So as lawyers, but even as non-lawyers, we are quite comfortable with the idea that law is there to make our lives better, to make our society a fairer society, etc. But also, just about everyone would agree that that is not happening. So the question then is, who has the responsibility to do something about this? And I very firmly believe that everyone has the responsibility, but law people, and by law people, I mean starting from law students to going up to the legislators and the judges and what have you, everyone who is engaging with the law in any capacity has this responsibility. So what I wish to argue is that legal knowledge, just like any other disciplinary knowledge, cannot be objective or neutral, and therefore always carries value preferences. The values pursued in any law are a matter of choice, and they result from contestation of ideas. Once it is accepted that laws pursue certain values, it follows that legal thinkers are the ones proposing and justifying these values. It is necessary, therefore, that the legal thinkers accept the responsibility for justifying their ideas about law. I am a teacher, and naturally I am beginning with the education system. So who has the responsibility for justifying ideas about law? I would suggest that every legal thinker does, but where do we start? I would say that we need to start with the education system. That is, how do we teach our next generation of legal thinkers? The primary issue for me then is, how do we teach about the nature of legal knowledge? And this is not just a question of personal style or preference, but the very foundational building block of how we understand the law and change the contemporary dominant modes of thinking. This view of legal knowledge will inform our teaching, but also the outlook of the next generation of lawyers who will not only practice as solicitors and barristers, etc., but will also be the judges, legislators, law reformers, policymakers, administrators, and teachers. In other words, they are the ones who will put into practice their understanding of law in all areas of life. Therefore, I believe very firmly that any meaningful law reform requires addressing the content and design of legal education. In the wider context, it means that our answers of what may constitute a just legal system requires us to reflect on what is our understanding of the nature of legal knowledge. It is not enough to suggest piecemeal changes to aspects of law or even to the Constitution for that matter. We need to develop a critical perspective on the role of law in creating a just society. The first proposition then is that creating a just legal system is essential to change the society to be better or to be more just. While my argument is addressed to the design of legal education, it is the combining of agency with the responsibility for the consequences of one's actions that is at the heart of my argument. My aspiration is that legal actors will be equipped to understand their agency in justifying or challenging the contemporary understandings of the law and the legal system, and thus help create a more just society for everyone. More widely, if all of us adopt the view of knowledge that makes center stage our agency in the process of the construction of any knowledge, it can actually transform our institutions and all other aspects of society. This is because the constitutive view of knowledge compels us to see how all of us are involved in this process. Once it is acknowledged that knowledge is not pre-existing, waiting to be discovered, it becomes easier to see also that we bear the responsibility for the consequences that follow from our views. Now, this is a central point that I want to make, that how we understand knowledge in any area, and especially in the area of legal system, legal institutions, is that it is something that is given to us and we use it. We use it to do various things, but we have nothing to do with actually bringing it into existence. And this notion that we are actually in the process of contesting ideas and then deciding which ideas become dominant and how do we manage to make certain ideas dominant and others irrelevant is an ongoing process in which all of us are involved. Now, this is also called the post-structuralist view of knowledge, and is widely discussed in other disciplines, but not so much in law. So in legal education, this view is denied by relying on a positivist conception of knowledge. A number of consequences follow from us adopting this positivist view of knowledge. First is that law assumes an objective nature. So whatever is law is then almost like it's a given and we just have to live with it. There are certain deficiencies that are identified, and we can tinker at the boundaries, but nothing fundamental needs to change. And in this view of knowledge, the thinkers do not have any personal responsibility for the consequences of their views, because they are engaging in applying or using objective knowledge that is given, rather than that they are involved in the creation of those ideas, creation of that body of knowledge. For example, the concept of division of powers between the legislature, executive, and the judiciary creates different sets of propositions for the respective institutional actors. The common story is that if we act within the boundaries of such divisions of power, we are not personally responsible for the outcomes of our decisions, as we are bound by the institutional norms. It's a very common occurrence in judgments of the various courts to find that the judges feel it is okay to say, I'm not in agreement with what I'm going to say, like I'm not comfortable about what my decision is going to be, but my hands are bound by the law. In other words, the law is given, I'm just applying it, and it is my institutional role to apply the law rather than tinker with it. So this is an institutional script that is available to all of us in whichever institution we happen to be in, where we are not actually engaged in creating a body of knowledge. We are more or less passive users of what is already exists. So in the same way, you have legislators who talk about making valid laws. Now, in legal education, this is one of the very big topics about what makes a law a valid law. The positivist understanding of what makes a law a valid law is that it is enacted correctly. That is, it has the right pedigree, that it comes from the institutions that are authorized to make laws. Now, in this definition, all you need to do is to decide whether a law is a valid law or not is to see whether it was enacted correctly. what happens to the content of what is enacted then becomes a different issue. It is available, the argument is available to us to say, that is not my concern, that can be the concern of somebody else. Now, think about it very, very carefully, that all of us go along with this point of view to a certain extent. So there are so many laws in our everyday experiences that we do not like, we do not agree with, we find difficult to deal with. But at the end of the day, we are so schooled in this idea that a law that is an existing law that has not been declared to be an invalid law is something that has authority over us, and we have to be prepared to live by it. Similarly, I can talk about specific examples a little bit later on. Judges talk about applying law and not making laws. That is, the judges are basically, this argument is available to them that if the judgment that they are giving is not a satisfactory judgment, in that I would rather that the result was different, but I can't do anything about it, because my institutional role is to apply the law and not make the law. Making the law is the responsibility of the legislators. I, as a judge, only have the authority to apply what has already been made. Now, we just have to examine it even cursorily to see that any judgment, any court case that we have has at least two interpretations of what a particular law is saying. So the reason we end up in front of the court is because we cannot agree about which is the correct interpretation. The courts exist because they have to be able to decide which interpretation of any rule is the valid interpretation. Why the judges can get that role is entirely different matter, but we can go to that later on. But at this point, this idea that judges simply apply the law invokes this fiction that the law is there, available. All the judge has to do is to put it to use in the dispute between them. But the dispute itself is about what the law says. So if the judge says, I'm simply applying the law, they are saying that I'm choosing between two interpretations. The institutional authority that we give the judges is that whatever the judge chooses as the correct interpretation is the correct interpretation. That is why they are a judge in a court of law. But think about it from the perspective of the judge. What is the judge doing? They are making the choice. So the choice that the judge is making is, how is that choice allowed? In institutional terms, we say that the authority of the judges, the choice that the judge has is not a unlimited, not a completely free choice. They are bound by rules of what they can do and can't do. And what they can do or can't do is basically to do with the rules of interpretation of rules, statutes. That is, there are rules of interpretation and the judge has to pick one rule amongst the ones that are available to them. And they are trained to do that so that we can trust them to choose the applicable rule in this instance. But what is a correct applicable rule becomes a fascinating area of analysis if you are allowed to go there. Most of the time we are not allowed to go there, and this is really the point for today, that the fact that the judge says we have given the judges the responsibility of giving us the ultimate interpretation of a law means that
I couldn't.
sorry. Does anyone want to say anything?
I think Mayo is just joining the video. Mayo, we've got Archana, who is giving us a talk at the moment.
They're acknowledging me. Sorry.
All right. So
You okay? Yeah, go ahead, Archana.
yeah, so basically then when the judges say that we have the authority to tell you what the interpretation of any law is, the agency of the law of the judge in choosing between at least two possible interpretations gets taken away from the sight of all of us. And what is the outcome of this is that the unsatisfactory outcomes are nobody's responsibility. So the judge gives you a judgment, but the judge is not responsible. The legislator made a law, but the legislator is not responsible for the values that are, or the value preferences that are embodied in the legislation. The question that I want to ask all of us to think about is, how have we reached this point and how may anything change? So the entire legal system operates on assuming that we are dealing with an objective set of rules, and various institutions have different roles to play. If the result, if the outcome is unsatisfactory, we can change a little bit here and there, but we cannot change anything at a macro level. What do I mean by we cannot change anything at the macro level is that you do not have revolutions through the legal system. So if you are very unhappy with the legal system, the solution that is available to you, if it is a solution, is to overthrow the legal system and replace it with something else. But is there another way of looking at the same set of circumstances? I'm saying that legal education can equip us to actually look at the assumptions on which our legal system is built. So at present, the legal education does not equip us to question the assumptions on which any argument is based, any theory is based. As a result, it is obscured from view that we are in the business of making choices at every stage. But since we claim that we are not exercising choice, we do not have to justify the bad consequences that so often follow. In legal education, and this is my, what can I say? This is my life's aim, or something that I have wasted my life on, is that I've tried to argue that in legal education, there is a tendency to think of it as technical know-how rather than about questioning the basis of any argument. A theoretical or selectively theoretical legal education focuses on treating law as an autonomous institution, autonomous from the wider society and its institutions. For example, what does equality mean for legal purposes? Okay, I want to underline for legal purposes. More often than not, it is formal equality. Why formal equality? Where do the standards for the abstract legal subject come from? So all of us know that legal system gives all of us certain rights by virtue of us being human beings. So we call them fundamental rights, we call them human rights. So every legal system has a slightly different terminology, but all of us know that we are entitled to certain basic rights. Equality is one of those rights in a liberal legal system. Now, where do the standards for the abstract legal subject come from? So the law gives you, in a liberal legal system, equality is a guaranteed legal right. But where do the standards come from that apply to the legal subject? So who's the legal subject is not any particular person. It is not a particular individual. It is an abstraction. I think all of you would agree with me that when the law talks about the legal subject, we don't really know whether the legal subject is a man or a woman, is white-skinned or dark-skinned, is heterosexual or another sexuality, what is their bodily abilities, etc. Why not? Because the law talks in terms of generalities. So the argument is that the rights, legal rights apply, are available to the abstract legal subject. But we still have to articulate the standards that go into our conception of what those rights are. And of necessity, those standards come from somewhere, and I would say that they come from lived experiences of the people who are doing the theorizing, who are doing the conceptualizing of these rights. Let me illustrate what I'm saying with an example. Suppose we are talking about a workplace which is on the 9th floor of a building. We do not expect our office workers to climb up 9 stories of a building as a matter of routine. It is considered to be beyond normal human capacity. However, if a building has 2 levels only, we can expect the workers to climb the stairs rather than ask for a lift. But is it reasonable to expect a person with a disability to do so? So do you see what I'm trying to show here is that we do have some notion of what is reasonable to expect from an individual, but whose capacities go into defining what is reasonable is left unarticulated. So a person with, what can I say, standard bodily abilities is supposed to be our standard of what we can expect a person to do when they come to work. But what if the person who comes to work is pregnant and has certain requirements? Immediately we go into the mode of talking about special rights, special considerations. What happens in talking like this is that the standard remains non-problematic, unproblematic, and we create a little window of generosity for those who may have special needs. But what I'm saying is that if we could articulate who was our reference point in deciding what is normal, what is standard, we would immediately see that the function of abstract ideas is that it camouflages that most of our laws deal with standards that reflect the lived experiences of the theorists, of the legislators, of the judges, and most of them happen to be, do I need to articulate this? So it sounds like a cliche, but do you see the point that the entire legal system is built upon not articulating that its abstract standards, its universal standards are actually the lived experiences of a male body that is able-bodied, that is more often than not heterosexual, etc. And that's why they can ignore those things, make them irrelevant in theoretical terms. So who has a right to vote in a liberal legal system? Everyone has a right to vote, because everyone basically means the person, it's not by reference to their gender, it is not by reference to their race, It is not by reference to their sexuality, etc. So when the framers of the rule were saying that everyone has a right to vote, every legal subject who has the age of majority has a right to vote, what are they getting at is that they're saying your gender is irrelevant, that your race is irrelevant, that your sexuality is irrelevant. And it is irrelevant for them. If you happen to be a white, heterosexual, able-bodied man, it doesn't matter what your gender is. It doesn't matter because they are not markers of disadvantage for you. If they are not markers of disadvantage for you, you extrapolate and say they cannot be markers of advantage or disadvantage for anyone else also. So therefore, we talk of legal rights in terms of abstract ideas, universal norms, and the argument goes that any time that you deviate from that, you are creating an exception to the rule. And yes, in certain circumstances, we will be magnanimous enough to give you that exception. But remember, you are being treated differently. You are being given an advantage. When a Pauline Hanson makes that argument, we get shocked. But when the legal system does exactly the same thing, we just think it is standard way of how law operates. So law, this may be an overclaim, but I would like to make it anyway. This idea that equality means formal equality, law is the main institution in our society which justifies this. So as a student, I used to wonder, if I can see that formal equality is problematic, why can't all other thinkers, why can't all these big names, big philosophers also see the problem? Well, why they can't see the problem is because it is not a problem for them. What is the issue for us is that if we want to change something, then this is the level at which the change has to come. So equality then cannot come through law by saying that the standard or your definition of who is a worker is somebody who is a reliable worker, who doesn't take time off, who turns up for work from 9 to 5 regularly most of the time, etc., and who definitely doesn't get pregnant. But if you're a worker who does get pregnant, here's a problem. We'll deal with the problem. We'll try to give you some special rights, but we will not change our definition of who is a worker. What are the normal standard requirements of a worker? The experiences of the male body get defined as the rights of a worker. Experiences of a female body then become exception to the universal rule. This way of conceptualizing laws is, according to me, the fundamental problem that has to be deconstructed, that has to be analyzed in every aspect of our knowledge creation. So not only for law, I would suggest the same for economics also. I would suggest the same for philosophy also. And with economics, my favorite example is that when economists talk about work, they write out of definitions the work that women do at home. They call it reproductive work. If all that work wasn't doing, your standard worker wouldn't be able to perform as they do in the workforce for wages. So women's work gets defined as exception to the rule. No wages apply to that, and we can disregard it. And we build an entire system on that assumption. But it is an assumption. Why did we as economists, make the assumption that definition of work is that produces value? it produces value because we have given it when it is monetary return, it is value. When it is actual reproduction of human beings, we call it not value. It is a choice. So the point, my main message basically is that we make choices in deciding what assumptions to make and how to justify them. And it is a function of abstract ideas that standards of the legal system are not even questioned. What is the consequences that we privilege some people at the cost of others? And if we want to change things, we have to go behind the claims of objectivity. So what am I saying? That there is no objective standard or norm. We choose them, but by reference to what is obscured by our conventions of reasoning and deploying concepts of objective truths. Sorry. This is the problem you have when you sit at home. Phones ring. My apologies. So what I'm saying is there is no objective standard or norm. We choose them, but by reference to what is obscured by our conventions of reasoning, concepts of objective truths. We need to give up these ways of thinking. So if we can transcend this one view of formal equality, for example, we would be on our way to creating a more just society. This is true both for the legislature and the university. With regard to legislation, standard of equality, I'm just using an illustration here. Standard of equality in most legislation is that of formal equality. And whether a problematic law is law or not gets decided by overly technical arguments about definition of law in positivist terms. So what I'm saying is that if we can open a possibility of saying that the standard of equality used, for example, in I don't know, in anti-discrimination law, or in sex discrimination law. So what is the standard of equality that is used in a legislation that was specifically designed to deal with the existence of discrimination on grounds of sex? If you haven't looked at it, it would make for fascinating reading to go and look at the definition of what is sex equality under the Sex Discrimination Act. It is using, so look at the enormity of the problem. Well, it seems like an enormous problem to me, but not obviously to the legislators. That why did we need a Sex Discrimination Act in the first place? We needed a Sex Discrimination Act precisely because your being a woman was turning out to be a stumbling block, was turning out to be a ground of discrimination against you. So we acknowledge that in legislative terms and enact a law, which is called Sex Discrimination Act. And what is the concept of equality that we use in it? That men and women will be treated the same. So what does a liberal legal system do in any case? The claim of a liberal legal system is that what is good about a liberal legal system is that it is based upon equality. So by definition, a liberal legal system does not discriminate against you on grounds of your gender, on grounds of your sex. And then we acknowledge that there is a problem and we create a Sex Discrimination Act, and then we turn around and interpret equality as formal equality. I have no words to express my frustration. I have spent my life doing this, nothing has changed. So what am I saying is that if anything is to change, conventions of legal reasoning have to change. That formal equality is not the only definition of equality. Understand that formal equality is using certain standards. Those certain standards reflect lived experiences. Once you acknowledge that your standard is actually invoking the capacities and experiences of actual human beings, you have to name who those human beings are. Once you name them, you see that what is good enough for a man may not be good enough for a woman, or what is good enough for a woman may not be good enough for a man. Maybe we need to start acknowledging that. So with regard to race, one of my, what can I say, I don't wear a bonnet, but one of my bee in the bonnet is the interpretation of whether the Constitution, whether Australian Federal Constitution allows for laws that can be discriminatory on grounds of race. The question has been discussed by the High Court of Australia. Judge after judge is saying that nothing in the Constitution says that the Commonwealth can only make laws for the benefit of a race. So I don't need to go through all the history of how we came to incorporate the racial equality standard in our Constitution. So we had a whole referendum, we changed the Constitution, we ended up creating the clause which said that Commonwealth has the authority to make laws for any particular race. And that clause, when it is interpreted by the High Court, what do a number of High Court judges say? They say we cannot say that the clause is only allowing laws to be made on grounds of race for the benefit of that race. In other words, it can be either way. There is nothing in the Constitution that compels the legislature that they can only make laws on grounds of race for the benefit of that race. How would you feel as a non-judge when you read that? Do you see what I'm trying to get at? That the judges who are the topmost minds of our community, topmost legal minds of our community, are probably all very decent people. They are not racists. They are not going around being rednecks or what have you. They are perfectly normal people like you and me. But how can they stand up in the High Court and say that the Constitution is to be interpreted that you are allowed to make laws not necessarily for the benefit of a race? What would you do when you go home? Would you feel bad about yourself? Would you be able to face up to your children and say that I gave a judgment today which allows the legislature to make laws to discriminate against Aboriginal people in my country? You will not do any of those things because you have available to you a method of reasoning which says, in my capacity as a judge, I'm bound by legal conventions, and legal conventions mean that I will give effect to the literal words that are in the legislation. I do not have to take personal responsibility for what my judgment is making possible. Do you get the point that I'm trying to make? So it's not a criticism of the person as an individual, of the particular judge. It is the method of reasoning that is available that lets you off the hook and says, you are only doing your job. Your job is only to interpret what is made available to you in the text. The text says the Commonwealth can make laws for any race. For any race. That's it. That law can be either for the benefit or for the disadvantage. It doesn't say it. So I cannot read those words into the clause, and therefore I'm absolved of all responsibility. The question for me is that could the judges have done something different? Was another possibility within the conventions of legal reasoning available to them? The short answer is yes. But more than that, what I'm saying is that this kind of an option should not be available to the judges, to any one of us to reason and say, these are the conventions of reasoning. I take no personal responsibility for what follows. I don't have to. Why not? If you and I are not doing the reasoning and justify the reasoning and justifying the ways of reasoning, then what are we doing? This is what I mean by that. If we can train lawyers to actually see that the decisions that they make, the choices that they make have certain consequences, and the consequences are their responsibility, and it's not like it's left out in the open and nobody has to take responsibility. So if we can change the conventions of reasoning to that extent, to make a connection between first that every thinker exercises agency, and second that in making choices, consequences follow, and those consequences have to be the responsibility of the person who's making the choices in their institutional capacity, in their personal capacity, in their whatever capacity you want to say. And this is what I mean, that if, can you imagine, I fantasize about it, that can you imagine if all our law students were empowered to think like this? So what kind of a next generation of legal personnel we would create? But we don't do that. Why don't we do that? Because that would be really changing society, and we are not really interested in it. And that is what I mean, that if we can change legal education in this way, I would say we can change education in all other disciplines in similar ways also, where the intellectuals of our society are not left off the hook for the consequences that happen from us adopting their ideas. I may be reading too much into what we can do as educators, but I hope that you will allow me the luxury of doing so. Can I stop here? I think I've spoken enough.
Thank you, Archana. Archana, are you saying that because we have set up institutions now and set up laws, that we've basically given up the reasoning to take responsibility for the way the laws are interpreted? Did I get that right?
Partly, yes. Basically, what I'm saying is that we haven't given up the responsibility, but we have created a system where responsibility doesn't attach to the individual. So I, as a judge, am operating within the institutional rules that a court is supposed to operate with. I'm not giving my personal interpretation. I'm being objective. So being objective means what? It has a certain definition. Being objective means I don't have any value preferences, and my role is to say, for example, apply the literal language of the rule. But where did that idea come from that the judge has to apply the literal language of the rule? That is one rule of interpretation. There is another rule of interpretation that says that if the literal language is not clear, then you go to what was the law enacted for, what was the purpose of it. But in deciding whether the literal rule is clear or not, I still am making a choice. I'm still interpreting. So what I'm getting at is that the rules of interpretation are there to keep the judges within their boundaries. We don't want judges taking over the world, etc. But in the process, we have also made it possible for them to say, I wash my hands off the consequences because I'm operating by the rules that you have asked me to operate by. That there are choices to be made at every stage is written out of our legal explanations.
Mm.
Once we make the choices evident, we make it that we don't ignore them, we acknowledge them, it would necessarily follow that we will also start taking responsibility for the consequences. For a judge who says that the Constitution can be interpreted that laws can be made for the benefit or not for the benefit of a race, do you think in the personal life there would be all right idea that legislators can make laws to disadvantage Aboriginal people, for example? They wouldn't. In their personal understanding, there's no problem in understanding that we want to create a society that is not racial discrimination practice in society. But when I put on my hat as a judge, my hands are tied by the conventions of legal reasoning. So don't blame me. Blame the conventions of legal reasoning. So this is what I'm getting at, that the processes of legal argument, the legal theories that allow us to do that, that's where the problem lies. So I'm not for a moment saying that we have chosen to give up responsibility. No, all of us, I'm willing to go along with the idea that all of us would like to do the right thing. Nobody likes to be told that they are discriminatory, that they are disadvantaging somebody else. Even if we do it, we don't like to be told that we are doing it. So if that is the case, there is a value for non-discrimination. But how is it that our institutional mechanisms allow us to practice discrimination in the name of being objective? That's what I'm saying. So what needs to change is how we understand how our legal actors behave, how the law operates. So idea that there are objective standards needs to be questioned. So one of the things that happens in the literature is that feminist writings are considered to be biased. They come from a perspective. How can you say that they are biased is only because you have available to you the option of saying that something else is objective. Do you see the point that I'm trying to make? That the claim that there is some way of reaching the objective truth allows us to identify everything else as less than objective, less than, if you like, true. But if everything came from a perspective, then you wouldn't have the option of denigrating some kinds of thinking as less objective or partial or biased or what have you. The problem with that kind of reasoning is then anything goes. What you think and what I think, we are free to think whatever we like. Is that the kind of society we want? No, that is where the argument comes that you take responsibility for whatever it is that you are advocating. Not that, I don't want to be too flippant about it, not that the devil made me do it, that law made me do it. No, you are making a choice, acknowledge the choice and what follows from the choice, and not you and me as individuals, it has to be across the board. Mm-hmm. So I'm asking really for institutional reasoning methods to change rather than that we as individuals change only.
Thank you, Archana. Are there any other questions at this stage?
Excuse me, Catherine Mayo. Can you explain in your words what Archana is expressing? Because I'm having trouble hearing her properly. Maybe, I don't know if it's my computer, but I'm having trouble really understanding the major point here.
Catherine, you want to go?
I think what you're saying, Archana, and I would need to be corrected, is that there is a search, or there is the assumption that there is an objective truth, and that the institutions we have in law and our legislators are basically using that premise, that assumption that there is an objective truth, and that there are certain parameters that they set for judges to interpret that objective truth, but that the reality is that the judges, although we don't want them to go outside the parameters, still have to select an interpretation, and that that interpretation is not really objective, because there is no such thing as an objective truth. But we set up institutions so that we can give the impression that there is an objective truth, but the actual organic truth of it is that everyone's truth is true to them and true to their world. And it's not that there isn't an agreement that, for example, the sun rises and the sun sets, but it is an agreement of all of us. But it's still, our subjective experience of that is still very subjective, and for that reason there is no objective truth. Did I get that right? Sort of.
Thank you.
Mayo, can I come closer to the microphone? Does that make it better?
Oh, okay. Thank you.
Is that better?
I think that may be the case, yes.
Okay. Basically, what I'm saying is that law has a way of pretending that it deals with objective truths.
Yeah.
That is, whatever is incorporated in law is actually desirable, is just, is fair, and the rest of it. When we identify areas of law that are problematic, we say, okay, let's change it. So a certain legislation, we identify a problem, we say, okay, the remedy is to go and change that law. What I'm saying is that the remedy is not in tinkering at the edges, but to start thinking about how does law get to make the claim that it is giving us objective, fair, universal standards. If you examine anything, whether it is the legislation or whether it is the judiciary, everywhere you see that there is an element of choice.
Yes.
That element of choice gets obscured from the view, and then we built upon this idea that whatever I'm allowed to do in my institutional capacity, I have no personal responsibility for. So, for example, with our legislation, at least at the federal level, if a law is enacted tomorrow saying that, I don't know, can I think of anything outrageous? Women with gray hair will have to pay more for traveling in public transport. Can you make that law? No? What will it do?
Well, I recall a time in the past where we were told to positively discriminate in favour of young women at high school, for instance, to give them opportunity in the STEM subjects and try and break down some of the stigmatic patterns that were happening. And sometimes discrimination can be positive.
True, but I'll come to that in a minute. But say the discrimination that I'm talking about is not positive. So the fact that you have gray hair and you're a woman, you'll have to pay more on public transport. can the legislator make this law at federal level?
I think the classic example actually at the moment that's very popular is the Black Lives Matter. If you make a law which says it's harder to imprison a black person than a white person, if you make a law which says you have to think twice before shooting a black person than a white person as a police win, surely that is a law which is very racist, yet has a very good intent.
Okay. All right. Let me work with that example. So what you're saying is you can use racial difference as the basis of your law, but as long as it is for the benefit of a race rather than to the detriment of a race. Would that?
If I was the policeman, though, I might be shot because I thought twice before I defended myself. So it's got an upside and a downside.
All right. So what may I suggest that this is an example of our understanding of non-discrimination is same treatment.
Sorry, say again, please.
Our standard of non-discrimination is that we treat every race the same.
Yeah.
The moment you make a law which says think twice before you shoot a black person, you have used race for the benefit of a particular race, but to the detriment of the other race, right?
Yeah.
What's the problem with this example is that our conception of equality is disengaged from the societal reality that in our society, whites and blacks do not occupy the same place. So the whites do not run the same danger of being shot by police as the blacks do. We can ignore that and say that any law that says that black people need protection from police shooting is discriminating against the white policeman only because we are saying that both whites and blacks have to have the same rights. Do you see what I'm trying to say? So the moment we say that blacks and whites should have the same rights, anything other than that is discrimination. Whether it is positive discrimination or negative discrimination, it is still discrimination. We are subscribing to the idea that equality can only ever mean same treatment. That is formal equality.
Yeah.
What I'm saying is that that same treatment, you can only talk about same treatment as equality when you deny the social realities that we live in societies that have social hierarchies. Domestic violence is another very good example of this. When you enact domestic violence legislation, what are you recognizing as a social reality? It is that violence happens in personal relationships, regrettably, but it does happen. But if you said that domestic violence happens most of the time against women, you are doing discriminatory talk.
Yes.
Isn't that a social reality that majority of people who suffer domestic violence are women? Why is it such a problem to acknowledge it in our laws? So law, we are doctored to think of as it only treats everyone the same.
Yeah, but women can use it as a law, as a weapon as well.
Absolutely. I'm not denying that for a moment, and I'm not denying that some men also will be subject to domestic violence. But what is the existing social reality? Can we name it in the law without calling it problematic?
So is it better to acknowledge that there is a bias in our society, or and then say to the police, you should be and making sure you enforce the law with regards to violence, full stop, not domestic violence, not Black Lives Matter, not whatever. It means that if a policeman walks into a violent situation, they will manage it exactly the same, whether on black, white, or green.
If that was the case, would you have a situation where majority of fatalities of police violence, say in America, are Black men, or that majority of people who suffer injuries for domestic violence are women? So you can't walk into a situation pretending that everyone is situated equally. Why are we so afraid of acknowledging that in our society?
Oh, I'm not saying don't acknowledge it. I'm saying there should be a general directive which you make the laws uniform for everybody, but till the implementers of the law, the police force, that they have to be aware of Black lives, domestic violence. Women tend to be the victims. Now, then we start getting into
Mitigating circumstances.
well,
It's still colour the police's judgment at the start. They're not coming into a situation and going, well, what am I seeing? They're coming into a situation saying, oh, I know that it's probably the woman who's being hurt. And I don't know that that's a fair thing.
Okay. Sorry, what did you say? Is that a fair thing or not a fair thing?
I don't think it is.
Yeah.
So
My
personal experiences are colouring my statements.
No, that is the point. That is precisely the point, that our personal experiences always inform our responses. But the law behaves as if our personal experiences don't matter. So not only as an enforcer, but also as the receiver of the law enforcement, personal experiences matter in every individual instance. And the idea that law should be sort of blind to that is what I'm saying, that actually by just saying that the law should be blind to that, we are not being blind to that. We are actually pretending that something isn't there when it is there. So the idea that a police person should walk in and judge the situation objectively, what is objective from the police person's perspective?
Exactly.
So if you happen to be I don't know, if you happen to be
Aboriginal or Torres Strait Islander.
I think Catherine will have to interpret.
I'm just raising the constant reminder in legal documents where you state whether you are of Aboriginal background, or Aboriginal or Torres Strait Islander, and I'm not, so I don't know what difference it makes. The bottom line is these people certainly need a lot of help, but so do there's a lot of white Australians who need help. And I find it quite offensive that the law and the rules for considering yourself an Aboriginal or from the Torres Straits enables you to more financial assistance. I'm not saying they don't need it, they do. But by isolating those Aboriginal and Torres Strait Islanders, I find it very hard to swallow when I know I hear of a lot of white people, whether they be Italian, Greeks, they are Australian. And they also need assistance.
Yeah, I hear what you're saying, but do you also, would you consider that by not identifying a person of indigenous origin, for example, you are denying the history of disadvantage. That is a particular history of that group of people. So there are Greeks and there are other immigrants and all that, I acknowledge. There are Anglo whites who are poor and who need assistance, acknowledge, but that there is a particular history of disadvantage of the indigenous people of the society. Should we be acknowledging it as a society or not? And if we start doing these small steps, would that be a step in the right direction or not, is the question.
I think a step in the right direction is helping all people. Just the other day, a statistic came up that adult Aboriginal and Torres Strait Islanders are 2% of Australian adults. And when you think of 2%, there seems to be a disproportion in
I think you have to ask, why is there 2%? And that 2% is incarcerated quite significantly.
Yeah,
so, you know, there's a huge background to all of that.
No, look, I understand that there is a huge background, but as I said, everybody needs help. And
but I think this is the point that Archana is making. She's saying, yes, the idea that everybody needs help and everybody should be treated equally is what's accepted.
yes,
But in reality, you take your own personal construct, your own worldview to any situation, and your idea of what is true or right or correct is not necessarily the same as someone else. So even in the policeman going in, one policeman may consider that he's giving very minimal force, and that minimal force may be enough to kill someone else.
Yep.
So it's a case of how, this is the point Archana's making, how can you come up with a general way of behaving that's going to be the same for everyone when everyone is so different? And that's where,
yes.
and that's exactly the point, Viv. It's never going to happen. That's exactly the point. Yeah, that's exactly the point. That's right. And Jane was just saying, Archana, we're not robots with robots rules. We need to be robots.
Sorry.
Yes.
I've
And-
seen
and-
a lot, and I can understand Jenny's views. It is very frustrating when you see a lot of opportunities given and you go to court.
Opportunities that maybe we have chosen, but not them. They haven't chosen those opportunities. I'm quite happy to acknowledge that.
There's some hard objective realities, which I am quite comfortable to say are objective realities. Look at the life expectancy of an Aboriginal, look at the incarceration rate of an Aboriginal, look at the health outcomes of Aboriginals.
It's appalling.
Yeah, there's some absolutely appalling numbers there. Now, there's nothing, that's my opinion there, they are provable facts.
Yeah.
If I say that an Aboriginal has a poorer opportunity in education, that is highly debatable because they get advantages that the Europeans don't get. But do they actually start from the same footing? Now, we could have a debate about that for hours, and that would be much more of a challenging debate.
What was, before we came, what was the lifespan of the Aboriginal?
Oh, I think it's
their own
better.
Choices.
Yeah.
They have made their own choices as to what they want to accept and what they don't want to accept.
But you see, I think
200 years ago,
acknowledge.
a European's life expectancy wasn't that high either.
That's right.
Yeah.
So it's very,
Yes.
hard to know.
and it's hard to make the statement that they're given a lot of opportunities, and by our standards, yes, they might be given a lot of opportunities, but the whole point is that recognizing what you are given and being able to make use of it is a very different thing to actually having something offered. It's exactly the same as communication. You can give an idea. I just had a phone call about a product that I bought, and they said, oh yes, over the phone we've listened to the record, and yes, we did tell you about the postage. Now I had to say to her, I'm not denying for 1 minute that you didn't send out the message, but I didn't receive it because I didn't have that concept in my brain. I didn't think that I would ever have to give it back, so I just didn't pay attention. I switched off. And I think that that's the point that Archana is making, is that everything is so idiosyncratic and so subjective that the law trying to make rules that are general for everyone really has to be, again, reconsidered. Yeah.
Well, I mean, really cultural. I'd like to ask a question about the worldview. Here we are in the white Western culture. I'm just thinking of all the various other cultures across the world, and that what's equality or normalcy in each culture is so different. That blows my mind.
Yeah, but we don't even need to go to other cultures. Even in our context, just think about how many people in this room have different ideas of equality.
Exactly.
Right? So that was the point I'm making, that all of us have those perspectives that we come from. Certain perspectives get classified as objective perspectives, and everything else gets classified as idiosyncratic or personal or particular views of certain sections of society. All that I'm saying is we should be alive to, we should be awake to how certain ideas assume the mantle of objectivity and others assume the label of alternative views. The idea that the only valid definition of equality is formal equality, that is all of us should have the same rights, is the fundamental idea that claims objectivity in our legal system. Now, I would like all of us, even if you don't agree with me, just think about it. Where does this notion come from that all of us require the same rights or same treatment because we are human beings? What is it that is common between you and me?
I suppose the dignity of the human being, Archana. I think that's really what human rights are always about. That people
they are, but if in the name of dignity you take away the capacity of, or you give the legislature the capacity to make laws against me on the grounds of my race, what happened to that dignity? Or that guarantee or that promise of dignity. So this is the point. Nobody denies that that everyone is entitled to dignity, everyone's entitled to fundamental human rights, but how we interpret them is our choice.
Yes.
And the kinds of concepts we deploy in interpreting is the problem, because that absolves me of the responsibility for the consequences that follow. So the High Court judges who say that in the name of equality, you can make laws that are either for the benefit or for the detriment of a race, they're not racist in their understanding. They're in their own understanding also, they're not racists. Nobody likes to be a racist. But if what I am saying justifies disadvantage on grounds of race, then how is it that I fail to take responsibility for that? Is what I'm saying is a function of this idea that you can have objective truths.
I'm going to disagree with something you said there.
Mm.
You just made the statement, nobody likes to be a racist. I'm sorry, that is wrong.
I take it.
The number of racists that there are in the world Every one of us is a racist to some extent.
Now you are making an overclaim. I was making an overclaim. What I meant was that in normal course of discussions, most of us, let's say that there are exceptions, but most of us are not comfortable with the idea.
Yeah. No, normal distribution curve, and I'm talking about the bit over on the far right-hand side.
Yes.
They are nasty people, and the rest of the curve is, I like to think, relatively nice.
I agree. But this idea that most of us are racist is also, it has an element of truth, but most of us also know how to camouflage it. We, in our hearts, we don't want to be seen as people who are less than fair, who are less than just, who are less than, what can I say, moral people. So isn't it then better that we articulate that whatever decisions, whatever positions we take, the consequences of that better not be problematic? No, we hide behind institutional ways of reasoning. That's all I'm saying. My argument is at the level of institutional reasonings, and these are the institutional changes that have to come about.
One of the problems of being in this venue is when they have a division, they let us know.
We're ringing. Can you hear the bells, Archana?
Yes.
Yes. We can hear them loudly too. Sort of stops the conversation when the bells start. 3 minutes. 4 minutes, maybe, I don't know.
You can go and vote now if you like. They might not accept your vote. I do apologise for this.
It sounds all right here.
We just can't get on with any discussions.
It really does.
Beautiful painting in the background. I love it. Look at that. I love that painting. Is it wrong?
This one?
Yeah.
Yeah.
Love it.
Thank you.
I'm sorry, Archana, I didn't actually introduce you to Rod. Rod, you might see from the background that he's an artist.
Yes.
He's actually, if you go up Park Street and you look up at the buildings, there's a dove and there's a white hand and a black hand. That's Rod.
Oh, right. That's impressive.
Yes.
Very
And
nice.
if you go down to Town Hall at the station and you look at the mosaics on the floor just before you actually go into the train station in the Queen Victoria building, that's also Rod.
Wow.
He's a clever boy, our Rod.
Yes, I get an idea, but I'll look up on my phone.
Okay.
Yeah. Oh, very nice.
It's a terrazzo, not a mosaic.
Right.
A terrace. Sorry.
Okay. It doesn't really matter.
Do they ever stop?
They do.
But then they start again.
You know, I was thinking that if you've got plenty of money, you can keep paying solicitors and barristers to go back to court and challenge any decision that a judge makes, as far as I can see. So I think there's another discrepancy. It's not just black and white or women and men or whatever. There's economic circumstances.
Definitely.
Let's talk about Archana now.
Good point, Rod.
Yeah, I think it is. I've seen it a lot of times. And I've seen people in court say to a judge, well, if you don't make the right judgment, we'll be back here.
Yes.
And the judge is being put right on the spot about how do I make a judgment that will bind all of these people. And it's a very difficult job.
It is. I'm not for a moment. So my argument is not directed at individuals at all, because I am willing to go along with the idea that most human beings are basically good and decent human beings. They're trying to do the best that they can. And it is
I think they change when they're going to have money taken. I think that's true. So if you think you're going to lose some asset because of a judgment, you will keep challenging. And if you've got the wherewithal to challenge it, you'll challenge it again. And you'll go from court to court until you think, well, I'm not going to win. And then you stop. So I don't think this idea that the courts are just these places where all these wise people sit around and discuss matters is an accurate picture.
No, but the point that I was making with regard to courts is that courts is our last port of call.
Yes.
Should be.
When the High Court,
Some people go straight there.
Yeah, when the High Court of the country says something, whether I like it or not, I have to live by it.
Okay, but getting to the High Court is quite a process.
Absolutely, not many people get there.
No.
Ultimately, what is the law on any given issue? We refer to what the High Court has to say about it. So I acknowledge everything that you're saying, but also that we better make sure that what the High Court judges are saying, that they should be sort of very alive to the enormous consequences that they have because of their judgment.
I agree, and I hope that they are. But the reality is that, and coming back to the domestic situation of violence, it is coloured that the woman will suffer, and that's fair enough. But as the police will tell you, their jurisdiction ends at the front door. What happens behind there, they've actually got no control over unless there's an AVO in their hand.
Correct.
Then they can walk across into a domestic space and start policing.
Yeah, I agree absolutely, and it's a huge problem. But with regard to domestic violence, can I also make one more point? That 30 years ago, it was like now we at least talk about it openly and think that it is an issue that needs to be addressed. 30 years ago, it wasn't even a identified harm. So
no.
There is a if you like, there is a movement, there is a change that is happening. We don't need to stop. Keep questioning and keep asking what further needs to change for us to actually address the problems that we are coming across, rather than hide behind this idea that both men and women are victims of violence to an equal extent. No, acknowledge that in our society, it is a gendered harm. It doesn't mean that some men don't get harmed, but why are we so afraid of acknowledging that it is a gendered harm?
A gender harm.
A gendered harm. Your gender determines whether you will be subjected to this harm to a larger or to a lesser degree.
Well, it's fair enough, because I'm not trying to be sexist, but women are the weaker of the sexes physically. And if a man's going to hit a woman, she stands a better chance of being harmed.
But it's not only physical weakness that we are talking about. It is the economic dependence that is really
It's psychological.
Yeah, well, I think that we are making big strides in terms of trying to balance the economy between the genders. It's just slow. But, well, we've just had our first female prime minister in the last 10 years, I think.
Yes.
So, if you look at those as measures, it's slow, but it is a change that's happening.
Yeah, but all I'm saying is that we can start thinking of change at the macro level of institutions rather than individuals only. That's all.
Right. Okay.
Do you want to say something?
Well, I was just going to say, if you think about it, at one point, women couldn't vote. So things change, and I think over the years there've been a lot of changes. The what was it, the pregnancy stuff and that used to drive me nuts as an employer. I'm sorry to say, it was a pain in the neck, but it was something that was legislated and had to happen. So there's lots of different things.
I've been noticing that the young ones, young females, becoming more and more violent. If you've noticed, 14 and 15-year-olds are using their fists today in a way that I didn't come across when I was younger.
Oh.
So I think they're catching up on the men.
That is not a good thing at all. That's not the kind of catching up we need. So that's the
No.
yeah.
I agree with you.
Equality can be at both ends of the scale.
Well, it needs to be, but
well, yeah, I don't know. I don't know if we want to solve the black incarceration rate by increasing the white incarceration rate. I don't know if we want to make life expectancies equal by reducing European death, European life expectancy.
yeah,
The other way around.
Yeah, exactly.
I take your point, but I think that, you know, this is another example altogether, but Aboriginal people are seen, and their artwork is seen as the major image of Australia's cultural identity. They have enormous profile in that area. But when it comes to money, things like Rio Tinto blowing up a mine, a sacred site or an art site, it just washes straight over and we move on.
Well, no, we don't. I think that as a nation, we're ashamed of that. And it caused the CEO to lose his job. I don't know what the financial implications were for them, but I believe it was huge.
But the things got blown up.
It still got blown up. It never should have happened.
Yeah, that's the point. And for some reason, it did happen.
Yeah, differences in values.
And that's only in the last year, I think.
Yeah. I know that it's order to
sitting on it here, Catherine, I think. I think a lot of it is to do with the differences in values and what we want to protect, what assets we see we have.
That's exactly right. Archana, I noticed that it's 5:45 and we're expecting to get out of here soon. It's been a wonderful discussion. As always, you set the cat amongst the pigeons and we start having amazing discussions. So thanks very, very much. I'd love to catch up with you very shortly. I think I'll give you a call and we can set up another time. Is that all right?
Yes, thank you, Catherine, and thank you for listening to me so patiently, all of you. And
Thank you.
Thank you, Archana. Been wonderful. And thanks the people on the Zoom meeting. Thanks for turning up. Mayo and Rod and Wendy. Lovely to see you again. So we'll see you soon. We're going to go off to lunch, a dinner, sorry.
Oh, lunch for some of us.
Yes. Thanks very much, everyone.
Let's go. Bye, Wendy. Love you.
Bye. Same to you, Becky.
Bye, everybody.
Let's go.
Meeting